All right, let's jump right in. We're going deep on criminal law in South Africa today. Got our trusty study guide here. We're going to try to break down these pretty dense legal concepts into something, a bit more digestible.
Yeah, I mean, what's so interesting is that South African criminal law is not just like a carbon copy of other systems. It's got its own unique blend pulling from Roman Dutch law, English law, even customary law. So
Its own beast.
it is. Get ready, we're about to unpack a whole lot of legal knowledge.
Let's start with the fundamentals. Chapter 1 of the study guide kind of throws us right into the deep end with general principles like, how do we even define a crime in South Africa?
Right, you can't just label any bad action as a crime, right? There are specific elements in South Africa we're looking for conduct. That could be doing something or even failing to do something when you should have. And it's got to be unlawful, match the definition of a specific crime, and be done with, a guilty mind.
Hold on, a guilty mind. So like if I accidentally bump into a priceless vase and it shatters, that's not the same as if I purposely smashed it.
Yeah, exactly. That's culpability. Chapter 1 breaks it down into two main types: intention and negligence. Intention means you knew it was wrong and you meant to do the bad thing. Negligence is more about carelessness. You didn't mean for the bad outcome, but a reasonable person would have seen it coming and acted differently.
So back to the vase. If I tripped and it broke, that's probably negligence. But if I was furious and aimed for the vase, intention.
You got it. And that makes a huge difference when it comes to, punishment. Intentional crimes usually have harsher penalties.
Now, Chapter 2 digs deeper into intention, right? It goes beyond just wanting to do something bad. It's also about, what you saw as a possible outcome.
It gets really specific here. The study guide points out different forms of intention, like dolus directus, where you're aiming for the bad outcome directly. Then there's dolus indirectus. The bad thing isn't your goal, but you know it's unavoidable to get what you want. And then, the tricky one, dolus eventualis.
Oh yeah, dolus eventualis. Doesn't that come up in a lot of those high-profile cases?
Yeah, it does. Dolus eventualis is when you can see a bad outcome as possible, but you go ahead anyway. It's almost like accepting that risk. Imagine street racing. You don't want to hit someone, but you know it's a risk, and you race anyway.
That's a strong example. And Chapter 2 really hammers home how hard it is to prove dolus eventualis in court, right? It's not just about what they did, but what was happening in their head.
Absolutely. Prosecutors got to show the person could see the harm, accepted it, and D still went for it. It's a high bar, but it keeps us from punishing people based on just accidents or recklessness.
Okay, so we've got intention. What about negligence? How does the law decide if someone was negligent enough for it to be a crime?
Chapter 3 unpacks that. It boils down to the reasonable person test. Would a careful, thoughtful person in the same situation have foreseen the bad outcome and tried to prevent it? If yes, and the accused didn't do that, it's negligence.
So it's not about what they thought they were doing, but how their actions stack up against this reasonable person.
Exactly. It's setting a standard for, responsible behavior. But the study guide makes it clear it doesn't mean everyone has to be super careful all the time. It's about the care a normal, cautious person would take.
So juggling knives on a busy street. Even if I'm convinced I'm skilled, a reasonable person would know that's dangerous.
Right. The law sets the bar for reasonable behavior, and if you mess up and cause harm, you could be held liable, even if you didn't, specifically intend to hurt anyone.
Okay, culpability. Intention, negligence, we've got it. But there's another piece when defining a crime: unlawfulness. Chapter 4 dives into this, and it's, less obvious than it sounds.
It is. Just because something matches the description of a crime doesn't automatically mean it's unlawful. There can be justifications, what Chapter 4 calls grounds of justification.
So sometimes breaking the rules is actually okay.
Think about self-defense. If someone attacks you and you fight back, you hurt them, that's technically assault. But the law sees you were protecting yourself, that's a justification.
Ah, so context is key. The study guide also mentions necessity, right?
Right. Necessity is when you break a rule to prevent something even worse, like speeding to get someone to the hospital. It's breaking the law, but if it's to save a life, it could be justified.
Like picking the lesser of two evils, even if it means bending the rules. But Chapter 4 says proving a justification is tough, right?
It's not a free pass. The accused has to show what they did was truly necessary, a balanced response to the threat.
Okay. Core elements of a crime: conduct, unlawfulness, and culpability. But before we get into specific crimes, let's step back. Where do these rules even come from? Chapter 5 tackles the sources of criminal law in South Africa.
And it's a mixed bag. South African criminal law pulls from legislation, common law, A&D customary law.
Wait, 3 different sources. Break it down for us. First up, legislation. That's laws passed by Parliament, right?
Exactly. It's like the official written rules. They define specific crimes and their punishments. For example, drug offenses are laid out in the Drugs and Drug Trafficking Act. That's legislation.
Okay, that makes sense. What about common law? It sounds a bit more old school.
Common law is like a living history of legal decisions. It's built on centuries of judges applying legal principles to cases. Many core crimes like murder, theft, assault, they come from common law.
So like a tapestry of, I don't know, legal wisdom from judges across time?
That's a great way to put it. Now, customary law, this is where things get interesting. South Africa has a ton of different cultures and traditions, and some communities have their own laws and practices.
So if something's accepted within a community, it might be lawful under customary law, even if it goes against legislation or common law.
That's the challenge, and Chapter 5 digs into this. South Africa has to find a balance, respecting both the official rules and the cultural diversity of its people.
It's like a tightrope walk.
It is. Sometimes those different sources clash, and it's up to the courts to figure out how to apply them fairly.
All right, we got where criminal law comes from. Legislation, common law, customary law. Now, Chapter 6 jumps into some big legal principles that are like key for figuring out someone's criminal liability.
One of the biggest is the principle of legality. It's also known as nullum crimen sane leg, Latin, of course. Basically, you can't be punished for something that wasn't a crime when you did it, even if they changed the law later.
So no retroactive punishments. That seems fair. It wouldn't be right to hold someone accountable for something they didn't know was wrong. Chapter 6 also talks about the actus reus requirement. What's that all about?
Actus reus is about action. For something to be a crime, there has to be a voluntary act or omission, something you did or didn't do when you should have.
So if I, have a seizure and accidentally knock something over, it's not a crime because it wasn't a voluntary act.
Exactly. But there are exceptions. Let's say you're a lifeguard, right? And you see someone drowning. But you just don't do anything. You have a duty to act in that situation. Your omission, not rescuing the person, could be a criminal act.
It's about the choice to act or not, especially when you've got a responsibility.
Right. Remember mens rea from earlier. That's also huge for criminal liability. Chapter 6 reminds us, in South African law, it's all about culpability, intention, and negligence.
Right. So proving mens rea means proving the accused had that guilty mind.
Yeah.
Either they meant to do it or they were negligent.
And how bad the mens rea is can change the severity of the charge. Like, murder needs dolus, intention, while culpable homicide is about negligence.
Okay, so actus reus, the act itself, mens rea, the guilty mind. Chapter 6 also points out another big element, causation.
Yes. Sometimes a crime hinges on a specific result. Someone dies, someone gets hurt. The prosecution has to prove the accused's actions caused that result.
So if I throw a rock, it hits someone, they get hurt badly, I could be responsible because my action caused the harm.
That's the gist. But causation can get complicated, and the study guide breaks down the difference between factual and legal causation. Factual is simple. Did the act lead to the result? If I hadn't thrown the rock, no injury.
So that's the but for a test, but for my action, no harm. But legal causation is different, right?
Legal causation goes deeper. It asks, is it fair to blame the person for all the consequences of their action?
So, I throw that rock, but then someone else comes and kicks the injured person, making it worse. My rock throwing started it, but legally, it might be tricky to untangle those actions and what resulted from each.
You got it. And that's just one example. Causation can be a real headache, especially with multiple people involved or unexpected outcome.
This is getting deep. Chapter 7 shifts gears. It looks at different people involved in a crime. It's not just about who actually commits the crime, right?
Exactly. South African law has different forms of criminal participation. You've got perpetrators, the ones who do the crime, but also accomplices and accessories after the fact.
Okay, let's start with accomplices. What makes someone an accomplice?
An accomplice is someone who helps the perpetrator commit the crime, knowing what they're doing. They don't have to be directly involved in the act, but their actions help it happen.
So if I'm the getaway driver for a robbery, I'm an accomplice, even though I never went inside the bank.
Exactly. You gave crucial support knowing it was for a crime. That makes you just as liable as the one who robbed the bank.
What about accessories after the fact? How are they different?
Accessories after the fact come in after the crime's done. They help the perpetrator, Or an accomplice, avoid getting caught, maybe hiding them, getting rid of evidence, giving a fake alibi.
So if I help my friends skip the country after they commit a crime, I am potentially an accessory after the fact.
Precisely. You're not in the original crime, but you're helping to cover it up, and that has legal consequences.
Okay, perpetrators, accomplices, accessories after the fact. But what if a group of people work together on a crime? Chapter 8 is all about the doctrine of common purpose.
Now, this is where it gets really interesting. Common purpose means that if a bunch of people share the intention to do a crime, they can all be held responsible for each other's actions, even if they didn't personally do every part.
So, like, even if I didn't physically assault someone during a robbery, I could still be charged with assault if I was part of the group that planned and did the robbery.
That's the idea. But Chapter 8 also says there are limits. Let's say the group agrees to rob a store, but one person suddenly decides to shoot someone. That wasn't part of the plan.
Would the others be responsible for the shooting, even though they didn't agree to it?
That's the tricky part. They'd only be liable if they knew or could foresee that the shooting might happen and went along with it anyway. Common purpose isn't about blaming people for things they had no way of knowing about.
So there needs to be some level of awareness or acceptance that things could go beyond the initial plan.
Absolutely. Common purpose is a strong tool for group crimes, but it's not meant to just punish everyone for what others did, especially if they had no control over it.
This has been an amazing deep dive into, like, the foundations of South African criminal law. We covered a lot, defining a crime, the sources of law, culpability, different ways to be involved, and the doctrine of common purpose.
And we've only scratched the surface. There's a whole world of specific crimes, defenses, special areas of law just waiting to be explored.
I can't wait to dig deeper. We'll be back soon for part 2 of our South African criminal law journey, so make sure you stay tuned. Welcome back. Picking up where we left off, untangling South African criminal law. Our trusty study guide is still with us, and last time we tackled the basics, like what even makes a crime. But now, let's get specific. Crimes themselves.
Right, because knowing the rules is important, but things get really interesting when we apply those rules to, real-world situations. Chapter 9 in the study guide takes us deep into crimes against the person. As you can probably guess, some of the most serious stuff out there.
Makes sense. Crimes that directly harm or threaten someone's safety, their well-being. Assault, murder, the heavy hitters.
You got it. The study guide starts with assault, which is, well, it's trickier than people think. Legally, it's any unlawful and intentional act using force on another person's body without their consent.
Okay, so if I, playfully punch my friend on the arm, technically assault, even though it's just messing around.
Well, theoretically, yeah. But there's this legal principle, de minimis non curat lex. Essentially, the law doesn't care about tiny things. A small, unintentional touch. Not going to land you in court.
That's good to know. But the study guide also says there are different levels of assault. Right, depending on how bad the harm is.
Exactly. It's not just about was there force, but the intent behind it and the result. Chapter 9 talks about assault with intent to do grievous bodily harm. That's where things get serious.
So they have to prove you weren't just trying to hurt them, but you wanted to cause a really serious, lasting injury.
Exactly. Proving that specific mental state that you acted deliberately to cause grievous bodily harm. The study guide has some good examples to show the different levels.
Now for the big one, the most serious crime against a person, murder. Chapter 10 goes deep on this one.
Murder, in South African law, is defined as unlawful and intentional causing of someone else's death, another human being. And it's not enough that someone died because of what you did. They have to prove you intended to kill them.
So if I'm driving recklessly, I cause an accident, someone dies, that's not automatically murder.
Right. In that case, it's about, did you intend to kill them? Or was it a really bad outcome of negligent driving? If it's negligence, it's more likely culpable homicide, not murder.
That takes us back to intention versus negligence from part 1. But murder cases get even more complex when you add in things like provocation. Chapter 10 talks about this defense, and it's, a bit of gray area.
It is. Provocation doesn't excuse killing someone, but it can maybe lower the charge from murder to culpable homicide. The idea is if someone provokes you so badly that you lose control, you kill them in that moment, it might be seen as a less serious offense.
So, someone insults me really badly, I react by killing them. Could I argue provocation?
Theoretically, yeah. But Chapter 10 makes it clear the courts are very strict on this. They look at the provocation itself, how much time passed between it and the killing. Was your reaction even reasonable compared to what they did.
Sounds really subjective, like the details matter a lot.
They do. There's a ton of debate about provocation, especially in cases involving domestic violence or other really emotional situations.
Okay, so we've got some of the big crimes against a person covered. Chapter 11 moves us into crimes against property.
Right, so these are offenses that involve harming or interfering with someone's property rights. Theft, robbery, fraud, crimes we see a lot, unfortunately.
Let's start with theft. Chapter 11 defines it as, unlawful and intentional appropriation of movable corporeal property belonging to another. Sounds simple, but I'm sure there's more to it.
Well, there's always more to it. To be theft, you got to take the property without the owner's consent. A&D intend to keep it from them permanently. So you borrow your neighbor's lawnmower without asking and don't give it back could be theft.
But what if I meant to give it back? I don't know, forgot. Still theft.
That's where intent comes in. They got to prove you intended to keep it for good. What you did, what you said, all of that gets looked at to figure out what you really meant to do.
Intent. The key to so many of these legal puzzles.
It is, separating genuine mistakes from deliberate bad actions.
What other crimes against property are in Chapter 11?
Robbery's a big one. Basically theft, but with violence or threats of violence added in. Think a mugging. Someone uses force or scares you to take your stuff. That's robbery, and it's worse than simple theft because it's dangerous for the victim.
Right, the victim's safety is right there in the mix. What about crimes like fraud and extortion? Those against property, too.
They are. Fraud is all about trickery. It's unlawfully and intentionally making a false statement, lying, basically, misleading someone to gain something for yourself or hurt them.
So making a fake online profile to, scam people out of money, that's fraud.
Exactly. And it doesn't have to be just money. Fraud can be any kind of harm caused by that deception.
And extortion, how's that different?
Extortion is using pressure or threats to make someone give you something. It's like a forced deal, where the victim feels they have no choice but to go along because they're scared.
So I threaten to tell someone's embarrassing secret unless they pay me, that's extortion.
You got it. It's about using fear to get what you want.
Okay, so crimes against property, from simple theft to more complex fraud and extortion. Chapter 12 takes us in a different direction, to crimes against the state.
Right. These offenses are about actions that threaten the stability and security of the country itself. Treason, sedition, stuff that undermines the government and public order.
So we're talking spying, inciting violence against the government, trying to overthrow the state, big stuff.
Exactly. Treason is about betraying your allegiance to the state. Sedition is more about stirring up rebellion.
These sound super serious with, major consequences.
They are. Crimes against the state can destabilize an entire country, undermine democracy, lead to chaos and violence. It's serious business.
Wow, this deep dive is really showing us just how wide-ranging criminal law is. From harming individuals to property, now even the state itself.
And there's still more to explore. Chapter 13 dives into the fascinating world of criminal defenses.
Defenses. Now this is where things get strategic. If someone is accused of a crime, what can they do to fight back in court?
Right. Chapter 13 lays out the different types of defenses, starting with ones that exclude unlawfulness. Remember grounds of justification.
Oh, yeah. Self-defense, necessity, where you technically break a rule, but there's a good reason.
Exactly. These defenses say, yeah, the act might look like a crime, but it wasn't actually unlawful because it was justified in that situation.
So if I defend myself from an attacker, even if I hurt them, I could claim self-defense to show what I did was lawful.
Right. Or I break into a store to steal food because I'm starving and desperate. I could try to argue necessity, even though stealing is usually unlawful.
But, like we said before, proving those justifications is no easy feat.
You got it. The accused has to convince the court that their actions were really needed and a balanced response to the threat.
Okay, defenses that get rid of unlawfulness? What about defenses that exclude culpability?
These target the accused's mental state when the crime happened. Remember culpability, intention, and negligence. These defenses try to show they didn't have the necessary mens rea to be guilty.
So, I'm sleepwalking. I accidentally break something. I could argue I didn't have intent because I wasn't conscious of what I was doing.
Perfect example. Automatism, like sleepwalking, can be a defense. The idea is you weren't in control, so you can't be held responsible like someone who acted intentionally.
Any other defenses like that?
Mental illness is a big one. If someone's mental state meant they couldn't understand what they were doing was wrong, they might not be criminally liable.
So, the law gets that mental illness can really impact someone's ability to form intent, to control their actions.
Absolutely. But these cases are tough. Chapter 13 explains how they use expert opinions, psych evaluations, and a lot of legal analysis to figure out the accused's mental state at that time.
Wow. Defenses add a whole other level to criminal law, trying to balance justice with the idea that sometimes people might not be fully responsible for their actions.
A tough balance, for sure, and that's one of the things that makes criminal law so interesting. It's not just about rules, but about human behavior, what people intended, and all the circumstances that affect their choices.
This deep dive into South African criminal law has been amazing. We've covered so much, from the specific crimes themselves to all these intricate defenses.
And we're not finished yet. In part 3, we'll look at some special areas of criminal law and think about what the future might hold for this constantly changing field.
Can't wait. Stay with us for more legal adventures as we continue our deep dive into South African criminal law. All right, welcome back for the final stretch of our South African criminal law deep dive. We've covered a ton of ground, the basics, some serious offenses, but there's still more to uncover. This study guide, it just keeps on giving.
It does, because criminal law isn't just about, individuals, what happens on the street. There are whole areas that deal with really unique situations, and that's what we're looking at today.
Okay, color me intrigued. What's first up?
Chapter 14 tackles something that's been getting more attention lately. Corporate criminal liability. We usually think about individuals in criminal law, but what about when a whole company, a corporation, messes up?
Yeah, good point. Usually it's lawsuits, fines, that kind of thing. Can a company actually be charged with a crime, like a person?
They can. The law's starting to see that corporations, as legal entities, they make decisions, they take actions, and those can have serious consequences. Chapter 14 explains how South African law holds those corporations responsible, often because of what their directors, officers, employees do.
So if a company pollutes illegally, or they're part of some huge fraud scheme, it's not just individual employees in trouble. The company itself could be criminally charged.
Exactly. It's about holding them accountable for a culture where crime is okay or even encouraged. A strong way to stop corporate bad behavior and protect everyone else.
Makes sense. Companies have to operate ethically, legally, just like people do.
Right. And with more and more cases of corporate misconduct, this area of law is only going to get bigger.
Chapter 15 takes a sharp turn into environmental criminal law. So crimes that hurt the planet, ecosystems, that kind of thing.
Exactly. Pollution, illegal dumping, poaching, they all have huge consequences for the environment and people. Chapter 15 shows how South Africa has laws like the National Environmental Management Act making those actions criminal.
So it's not just permits and fines. There are real criminal charges for harming the environment.
Absolutely. And the penalties can be serious. Fines, prison time, even having your assets taken away.
It's reassuring that these offenses are taken seriously. Protecting the environment is protecting our future.
For sure. And as climate change keeps making its impact felt, environmental criminal law will be even more crucial for holding polluters responsible for safeguarding the planet.
Corporate crime, environmental crime, anything else on the list?
Chapter 16 takes us into a world that's constantly changing. Cybercrime. As we use technology more and more, criminals are using it too, finding ways to commit offenses online.
Cybercrime is a hot topic, for sure. Data breaches, hacking, online scams, it seems like we hear about it all the time. What kind of stuff counts as cybercrime?
It's a wide range. Chapter 16 mentions hacking, phishing, identity theft, online fraud, even spreading harmful content like child pornography.
So if someone steals my credit card info online, spreads lies about me on social media, that could be cybercrime.
Definitely. And South Africa has made laws to address these issues. Chapter 16 points out the Electronic Communications and Transactions Act and the Cybercrimes Act. They're both aimed at stopping cybercriminals and protecting people.
Good to know the law is keeping up with technology and how crime is changing because of it.
It has to. Cybercrime is always evolving, but these laws give a framework for holding people responsible, making sure the digital world is safe and secure.
This deep dive has been incredible. We've gone from the very basics to some really specific, complex areas of criminal law. It's clear this area of law, it never sits still, always adapting to new problems and protecting society. Any final thoughts as we wrap things up?
I think the biggest takeaway going through this study guide is that criminal law isn't just a bunch of rules. It shows us what we value as a society, balancing individual rights with safety, security, making sure justice is done right, fairly, and effectively.
That's a great point. The law isn't static, it's alive, it changes along with the world around us.
It does. And as we move forward, we got to stay informed, talk about the law, what it means, and push for a justice system that really represents what we believe in, protects everyone's rights.
Couldn't have said it better myself. Huge thanks to our listeners for joining us on this deep dive into South African criminal law. Hope you've learned a lot, gained a new understanding of this really fascinating area of law.
It's been great exploring all this with you.
Until next time, stay curious and keep those legal minds sharp.